Hi. In the first video, I talked about human rights as a philosophical idea, particularly stemming from the period of the Enlightenment and then going through the French Revolution and US Declaration of Independence to finally become positive law and become more than just what is written down in the treatises of some authors. Now, in this course, we talk about international human rights law, in particular as it came about since 1945. And that is an important marker because it marks the creation of the United Nations, which, as we will see in the following weeks, is really one of the main institutional frameworks in which human rights law is laid down nowadays. That said, it is really worthwhile to look at what existed pre-1945 in terms of the protection of individuals or specific groups. As you know from our course last year, public international law and international human rights law is just a part of that, is state-centric, which means that in the very first place, it is about the rights and obligations of states, which means that the protection of individuals, the protection of groups really is something that is not by nature or very obviously something that you would be achieving through international law. But then again, as we have learned from the philosophical idea of human rights, there is a lot of pressure to make states or any governing authority really accountable and to make it rule better and more just. So the idea that at some point also international law would come to address these questions is, from that perspective, also not particularly surprising. And in this context, so the pre-1945 context, we can basically point to three elements that really imbued this idea. And this would be my answer to the second question that I gave you. First, there is obviously the law of armed conflict, international humanitarian law, the notion that the gruesomeness, the cruelty of warfare should be diminished and that individuals, in particular those who are not participating in the hostilities, should be protected from violence. And to be a bit more specific, we can point to the 1860s here. We talked about this in last year's course. The Battle of Solferino, the creation of the International Committee for the Red Cross, which then at the end of the 19th and beginning of the 20th century gave rise to the first Hague Conventions and Geneva Conventions that were dealing with these topics of how to diminish the suffering created by war. Secondly, we have the anti-slavery movement that started in 1771 and really eventually culminated in the Anti-Slavery Convention of 1926. So the notion that slavery is not just something that should be outlawed, but really in a way a crime, in more modern terms, a crime against humanity, found footing in the 19th and 20th century. Modern forms of slavery, such as human trafficking, continue to be a topic even today. So the fact that these norms were created and they eventually were recognized as legitimate and right doesn't mean that implementation doesn't still raise important challenges. And finally, we have the protection of the rights of religious, linguistic, and ethnic minorities. That really was one of the main goals of the League of Nations that was created after World War I. And although this eventually failed in a way, we can see here some of the supervisory mechanisms, kind of international bodies coming up that then become part and parcel and really much more authoritative and powerful in the United Nations system that we saw emerging after 1945. So these three aspects, these three developments show a gradual shift from the state-centric nature of public international law, a slow gravitation towards the considerations of the welfare and therefore the rights of individuals and groups of individuals. Now this then finally brings us to 1945, the creation of the United Nations, and perhaps even more specific or more precise than 1948, which was the moment in which the Universal Declaration of Human Rights was passed as a General Assembly resolution. There is a lot to be said here, but I'll try to keep it short. The Universal Declaration really plays a central role in the human rights system. It really marked the starting point of the creation of a much more rich and much more complex architecture, but it's really the foundational element in it. And here, the role of the Human Rights Commission, led by Eleanor Roosevelt most famously, can hardly be overstated. Finding a consensus on a list of universal inalienable rights through the participation or with delegates from different continents participating was really difficult, but arguably would not have been possible if not in this specific moment. So there was a sort of window of opportunity, but therefore also a sort of pressure to make it happen. In other words, had this endeavor failed, had Eleanor Roosevelt and the Human Rights Commission failed, we certainly wouldn't have the international human rights system as we have it today. Now, from a legal standpoint, things are actually a bit more complicated because the Universal Declaration of Human Rights is not per se as such legally binding because it is a UN General Assembly resolution and they are not legally binding. That being said, there is a consensus these days that at least most rights in the Universal Declaration constitute customary international law. One only has to look at the many UN conventions that came about in the decades that followed to confirm this point. So again, the UDHR is a starting point of a much deeper and more profound development that put the rights that were initially philosophical ideas into positive law at the international plane. It's probably worthwhile here to mention in particular the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, which together with the UDHR creates the so-called International Bill of Rights. But obviously there are many more conventions, many more treaties, not just UN treaties, but also regional treaties. And we'll be spending the first part of this course looking in detail at what they encompass and who actually is a part of those conventions. That concludes the second clip. I'll now move on to the idea of human rights as a global discourse.